today we'll be tackling the topic of international working, and we'll be asking the question a lot of employers are facing from their employees. I would like to relocate abroad, but I would still like to keep working for my employer remotely. Am I permitted to do this? And this is a question we're seeing more and more. The COVID-19 pandemic changed the way we work. And previously, employers, of course, used to post employees to different countries. But now we're seeing the employee coming to their employer saying, I really love working for you, but I want to work for you from a different jurisdiction. So the employer might be in the UK, and the employer saying, well, I want to work from Dubai or Spain or Greece because perhaps their partner's there, perhaps this is for lifestyle reasons, etc. Now, this gives rise to several considerations and challenges for both the employee and employer. And today we'll be looking at those with a focus on employees wishing to settle in Dubai, Vietnam, Singapore, and Australia. So we'll have a specialist view from those countries. Now, before going into the country-specific issues, I'm going to be giving an overview of the key areas. Those of you who attended the first in the series, apologies. I will be covering the same ground I covered then, but it's for those who didn't participate in the first one. So on the first slide here, we've got the key issues that you need to think about, and I'm going to go through these specifically one by one. So the first one on the next slide is local employment rights, and that's because employees, you might be based in a certain jurisdiction, and often we have employers saying, well, the law of the contract is, say, for example, a US contract, you've got a US employer, surely it's US law applies. Well, that's not necessarily the case, because if an employee is based in a certain jurisdiction, there's a good chance that local employment law will apply to them. And if it does, that overrides what's in the contract. There's certain laws you can't contract out of. And it might have to do with things like compulsory holiday, severance or redundancy, employment or termination rules, etc. It may trigger certain benefits, such as pensions benefits. So you should always look to see what jurisdiction the individual's in and what employment rights they might inherit by going in that jurisdiction. The next thing to think about is, so moving away from the employment topic, we will be focusing mainly on employment today, but just looking at it from a tax perspective. When an employee is based in a certain jurisdiction, we really recommend that employers get advice to make sure that their presence there does not create some sort of taxable presence like a permanent establishment in that country. And rules are determined by where the employee is based. But as a rule of thumb, the risk is generally greatest where the employee works from a fixed place of business, such as an office, rather than simply from home. And or if they have the authority to conclude contracts or bind that employer in that jurisdiction, that can create a greater risk. But as I said, it does depend on the country. And what are the implications? Well, that may bring your company in certain profits attributable to that establishment in that jurisdiction, may be subject to local corporation tax, for example. And there are other tax considerations, particularly for senior employees. You've got the VAT risk. For example, if services are being provided by that individual from that jurisdiction, can it create a VAT risk? If you've got a senior board member, what impact does that have on the company's tax residents if they're attending board meetings from that jurisdiction, for example? Is there withholding tax risk if you're obtaining loans which you're using in that jurisdiction? It's not necessarily the case that these things will apply, but what we want to showcase here is really to get advice is really important. But the next issue is employee tax, and moving back into the employment sphere. Obviously, where you have an employer and employee in the same jurisdiction, it's relatively straightforward. For example, in the UK, you have a UK employer, a UK-based employee. The employer is responsible for deductions for tax and social security, national insurance, etc. So it makes it quite straightforward. But where the employee is in a different jurisdiction, where does that responsibility lie? Firstly, do they fall within the local tax rules? Are they subject to local taxes? If they are, is that responsibility on the employer? Does the employer have to register with the local tax authorities? In fact, does it have to set up an entity there to do that? Or can that responsibility be passed to the individual, to the employee. You'll have to look for whether a double tax treaty is in place, whether there's exemptions from social securities. These are important things to think about. And to guard against certain things, you may consider whether you should put a tax indemnity in the employment contract, so that if there's any issue in relation to accounting for tax, you try and push that liability onto the employee as best you can. Statute may not allow you to do it fully. The other thing, of course, a major issue is immigration. And that employee may want to work in that different jurisdiction, but do they have the ability from a visa perspective to work in that country? Can they obtain a visa? Perhaps they'll be able to piggyback off their partner, for example, if they're going with their partner. But otherwise, if you as an employer don't have a presence there, are there even options for that individual to get a visa? Or does that employer have to have some sort of presence to register with the authorities? For example, in the UK, employers need to register with the Home Office in order to sponsor employees for visas in that country. And it will depend on jurisdiction and nationality. It also works the other way around. So again, using the UK as example, you've got a UK-based employer, the employee is in Australia, but you want them to come to the UK for a month to work on a specific project, and you need them in the office. If they don't have a UK visa or not a British national, can they enter? Do the visitor rules allow them to do that? So that's the flip side of it. There's that second angle in terms of immigration permission. Now, of course, when you get all these issues and practical difficulties of employees setting up abroad, you're going to get companies that come to fill that void. And what we're seeing is the rise of the professional employer organizations, or the employer of record, companies that come in and say to you, we're an HR platform, we will handle the onboarding, all the equipment, the payroll, the contract. We will hire these employees and effectively second them or pass them to you as consultants. You don't need to worry. We take all of that away from you. And that can seem very attractive, at least on the face of it. But there are consequences and things to think about when you engage companies such as this. Firstly, the contract of employment, that will be with that employer of record. Does that have the same level of protection you would as an employer, in terms of confidentiality, post-termination restrictions, etc.? Also, where does the liability lie for fault or for claims by the employee? Is it being passed on to you as the true employer, or is it with the employer of record? So do look at those contracts carefully. Does that jurisdiction have this concept of dual employer? Will they look at who the real employer is and effectively say, well, it doesn't matter if you've got an employer on record, you're the one who's really employing this individual? Does that country even allow such an operation? And some of the issues we've highlighted are not necessarily cured by this employer record. And lastly, just a few small practical matters you have to think about. For example, public holidays. Does the employee get public holidays in the country in which they are based, or the country of the employer? What about working hours? Do they operate in the employer's working hours, or where the employee is based? That might work if there's only a 1 or 2 hour difference, but what if there's a 4 or 5 hour difference? Is it practical for that employee to be working the working hours that you as the employer operate in your country? And the other thing I wanted to highlight quickly was insurances. You may provide, for example, private medical insurance or other cover for your employees. Does that extend to employees who are based in another jurisdiction? Or do you have to get out special insurance, which might be costly? Or do you just give the employee an allowance to cover that? I'm now going to hand over to Charlotte Bijlani, who's the head of our Dubai office, who's going to give us the view from Dubai. Over to you, Charlotte.
Thank you, Devan. So I'm Charlotte Bijlani. I'm a partner in the dispute resolution team in Dubai, and I'm going to focus on the position in relation to remote working in the United Arab Emirates. You may have heard that Dubai has become an extremely popular place to live, particularly since COVID, and it is really emerging as a hotspot for remote cross-border hiring. You see many nationals moving over to this jurisdiction to live because of the ease of living here. It's a very tax-friendly jurisdiction, and over the last couple of years, the UAE has really taken quite significant steps to attract remote workers. And just before I go into some of the rules and regulations that have been introduced into remote working, I will just explain briefly the legal landscape in the UAE, which is quite unusual to some other jurisdictions that we will be speaking about. In 2004, the DIFC, Dubai International Free Zone, was created. And that was really done to attract foreign investors into the market. It had a very favourable tax regime, and it has its own separate laws, which are separate from the laws that apply to what is called onshore Dubai. And then in 2013, we saw the creation of the ADGM, which is the Abu Dhabi Global Market Free Zone. And again, that free zone has its own laws in place. And again, it was created with the initiative of, again, attracting more international investment. And the unusual situation we have in the region is that in the DIFC and the ADGM, the laws that apply are heavily modelled on English law, and they have their own separate court systems. Whereas the laws that apply elsewhere in the UAE are based on the civil law system, and there is a separate civil law court system that applies. Here we've got an overview of how the employment laws differ depending on whether you are employing someone onshore Dubai or onshore in the UAE or within the free zones that I've just mentioned. And I'd say generally that the employment laws that apply are less stringent on employers than they are in some other jurisdictions, such as in England. There are no concepts, particularly in the free zones, of unfair dismissal or constructive dismissal. And I would say that generally it's easier to terminate an employment. Onshore Dubai or onshore in the UAE, you generally have to have a legitimate reason, and there are provisions providing for compensation to be payable in certain circumstances, which is generally capped at 3 months. And in the free zones, you have the right to terminate for cause. If you are in that situation, it's very important to ensure that you document the reasons why you're terminating someone, because that will be crucial when if you find yourself in a dispute. If we could move on to the next slide, please. I'm not going to go to every point, I should say, on the slides. You can read those in your own time. But another point to mention is that onshore Dubai, you have this Emiratization policy. So if you're a large organisation, you have to make sure that at least 2% of your staff are Emirati. So that's an important requirement for large organisations. And the next slide, please. There are slightly different periods that apply for annual leave and periods for sick leave and notice periods, depending on where you're established. And I've set those out in detail on the slide. And could we move on to the next one, please? And one of the key points to be aware of if you're employing someone in the UAE where you have an established presence is that you have to pay an employee when their employment terminates an end of service gratuity. The irritating position for employers is that this gratuity would build up over the years of the employment. And so you would have to factor into your business and accounts the provision for payment potentially large sums if you're dealing with employees who've been employed for long periods of time. That end of service system has been effectively removed in the DIFC, where you now have a contribution system which operates a bit like a pension scheme. So every month the employer will be paying into that scheme an amount of money by reference to how much the employee is paid. Dispute resolution is quite important. If you're onshore, you will potentially be having to deal with the dispute in the onshore labour courts, and that is all conducted in Arabic. There are no hearings, unlike the system, for example, in the free zone. If you're in the free zones and you find yourself in a dispute, depending on the amount involved, you may need to have the dispute determined in the small claims tribunals. Otherwise, you end up having to go to the courts in the DIFC or the ADGM. And typically, because of the way the compensation provisions apply, you don't tend to see a huge amount of disputes other than really in relation to claims for large bonus payments. So it's important in this region that your contract's very clear on bonus entitlements. If we could move on to the next slide, please. So now, in terms of remote working in the UAE, as I mentioned at the beginning, the UAE has introduced various legislation aimed at promoting remote working. But of course, there are certain conditions that apply for people to be able to obtain visas and permissions to remote work in this jurisdiction. If we could just move on to the next slide, please, and that's looking at what the position is at a federal level. So employees who are employed abroad can apply themselves for a virtual work visa, and that visa, if successfully applied for, will be valid for a period of 1 year. And there are certain eligibility requirements, particularly income requirements. There needs to be proof of employment and evidence that work can be carried out remotely. It's not entirely clear what that evidence has to be, but I think on a case-by-case basis, you particularly look at the job description and decide whether it can be done remotely. And it's also necessary to have the medical insurance either purchased in the UAE or evidence that the insurance that the employee has is valid for use in the UAE. Then in relation to Dubai, Dubai has recently introduced its own virtual working scheme. And this is slightly different from the federal scheme that I mentioned earlier, in that it allows an employee to sponsor their spouse and children, as well as obtain a visa for allowing them to work. And that the requirements for those visas are very similar to the one I just mentioned under the federal scheme. And if we could move on to the next slide, where we talk about the impact of the employment laws on remote working. Generally, the employment laws I mentioned earlier will not apply to remote working arrangements. There are certain requirements in relation to when employees enter the jurisdiction once they've got the visa. But generally, most of the provisions that I mentioned under the federal law will not apply to the remote working arrangement. And then if we could move to the next slide, I would just briefly touch on the situation in the free zones. The free zones have their own separate systems. So in the DIFC, remote working arrangements are classed as secondments. Generally, an employee has to obtain what's called a secondment card to work for an employer in the DIFC. And that can be obtained for a period of up to 12 months. Or if it's required for longer, there needs to be a specific approval by the DIFCA, which is the authority that exists in the DIFC. Some of the provisions of the DIFC law, employment law, will apply to the arrangements. I've set those out on the slide. There's a general need to make sure that the working environment is safe, etc., and for health insurance to be in place. And then if we could just move on to look at the situation in the ADGM, it's strangely classed as a non-employee under the legislation that exists in the ADGM. But essentially, there's a process for someone to apply for a temporary work permit. The employee must be either a GCC national or hold a valid residency visa That's different from the position in the DIFC. Again, the employment must be in place for a period of 12 months, of at least 12 months. And if we could just move on, just to look at the impact of the ADGM employment law. Generally, most of the provisions don't apply. There are special rules that apply under the non-employee employment law, but those are focused on the terms and conditions for getting the work permit, allowing the remote working. And then lastly, on the last slide, I'm just going to briefly touch on the situation where someone employed in the UAE wants to work outside of the UAE. There is a need for caution in relation to residency visas, because if someone is out of the jurisdiction for more than 180 days continuously, they will have their residency visa revoked. It doesn't apply to people who've got what are known as golden visas, which are 10-year visas for senior management employees, or for people who own real estate here. And there are, of course, tax implications. For example, if I was to go and work in the UK, I would need to be careful of the 90-day rule for being in the UK and the 30-day working rule. That's the end of the presentation in relation to the UAE. So I will now pass back to Devan.
Thank you, Charlotte. And I found that really interesting, actually, the way the UAE is embraced, the remote working side. And, for example, the virtual working visa, it's certainly a stumbling block in many jurisdictions, particularly, speaking from a UK perspective, I always see that as an issue. So it's interesting. And of course, the weather there makes it an even more attractive place for people to locate. I'm now going to hand over to Alan Polivnick, who's a partner in our Sydney office, to give us the view from Australia. Over to you, Alan.
Thanks, Devan. I'm going to talk very briefly about the position in Australia. It's not quite the same as the UAE, and I guess it's, notwithstanding the weather's more attractive than some places. The short answer is that the position in Australia is a little bit more complicated for foreigners. For Australians, it's less so. Everybody coming to Australia, regardless of the purpose of your visit, requires a visa. So to some degree, it's very difficult simply just to turn up here. You're going to either need a tourist visa or a short-term visa. A work visa will require sponsorship by a company. This can be done by companies who don't have a presence in Australia, but it does create issues for those companies. It will be considered in some regard to be an Australian permanent establishment for tax purposes. What I think is also important is that the company will have to meet various requirements as the employer of someone in Australia. Australian workplace employment laws apply equally to Australians and foreigners, regardless of the capacity in which foreigners are in Australia, although I think the law will assume you have a legal basis to be here and to work. For foreigners coming to Australia, probably the biggest challenge is Australian tax. There are double tax treaties, but once you're here more than 183 days, you are considered to be earning income in Australia, and with very few exceptions, you will have to pay tax here. A key issue is going to be the tax residency of the employee in terms of how that works and what that means. In many cases, the tax authorities will look to see if the income is sourced in Australia. And for remote workers, a key trigger there is that if you could do the work overseas, but you choose to do it in Australia, they will deem that as Australian sourced income. The other basis, of course, is if the employee's usual place of work is Australia. And again, if you've chosen to come to Australia and work remotely here, they will look at that. So the threshold is relatively low to trigger that. What that means is that you may end up paying Australian tax, which is a lot higher than, for example, Singapore or Hong Kong, and substantially higher, I think, than the UAE. That needs to be factored into employment contracts. In many cases, what we see is either tax equalisation clauses or some form of adjustment of the salary to make sure that the net salary is equivalent. So in terms of employers, the position is not quite clear cut in terms of not having an Australian presence. There are quite a lot of requirements in terms of registration here. The company can register as a foreign entity. It can establish a wholly foreign-owned subsidiary. But once you do that, you have a permanent establishment in Australia, which creates various corporate income tax complications that will generally relate to income generated in Australia. What we have done is assisted clients to structure the Australian operation so that the income is not necessarily earned here, although it is increasingly difficult to do that, particularly with transfer pricing regulations and various other measures to ensure that companies doing business in Australia are paying tax here. Employees may have some difficulties enforcing their rights by not having a local entity, and the employment tribunals and labour courts don't tend to have extraterritorial jurisdiction, which creates an issue. The regulator, including WorkSafe Australia, doesn't have any such concerns, and both WorkSafe Australia and the Competition and Consumer Commission will regularly prosecute foreign companies with no actual presence in Australia. The employer's obligations in terms of salary will be governed by Australian law, regardless of what the employment contract says. And that requires pay-as-you-go deductions, withholding, and contributions to superannuation, which is a government scheme with employer and employee contributions. There are also requirements for the employer to report income to the Australian Tax Office of the employee and to provide the employee with an annual financial statement for the purposes of their tax returns. If the employer provides non-cash benefits, such as it provides a place to work or a car or other benefits, those may be subject to fringe benefits tax levied on the employer. And again, that will require the employer to have some form of Australian registration or presence to do that. The tax office also will pursue offshore entities to pay their tax. And that is often a fairly big factor in how the deals are structured, is in terms of the tax implications for the corporation. Now, as I said before, employees in Australia, regardless of their nationality or their status, are all treated equally and are all entitled to the same rights and obligations under the law. Those rights are fairly regularly tested and enforced, and employees are fairly aggressive in enforcing their rights where they are aggrieved, whether they are unionised or not unionised. So there are a number of obligations on an employer, regardless of whether the employer is based here. One of the issues, of course, is employee health and safety, and there are statutory and mandatory obligations on an employer to ensure a workplace is safe. One of the issues that has arisen with people working from home and working remotely in a place of their choosing rather than in a facility or provided by the company or the company's premises is to what extent that duty is either reduced or minimised. Some of the decisions have made it clear that an employer must still provide a safe place of work. Other decisions have not. In time, I guess we'll see with some of the insurance claims that are coming through the system as to whether workplace health and safety insurance is covering the injuries of people who were working at home at the time they were injured. That's probably going to be a big factor in whether employers will allow employees to work remotely by choice in the future, particularly since particularly if the obligations cannot be restricted, limited, or excluded. Beyond that, there are also employment requirements. Those include a maximum number of weekly hours of work, annual leave, sick leave, carer leave, public holidays, and flexible working arrangements. One of the challenges with flexible working arrangements is that where you are working remotely and you don't have fixed working hours, it's very difficult to ensure that employees only work a certain number of hours a day or a certain number of hours a week. That's an issue which is currently being tested, and one which the sort of COVID-related working from home schemes really highlighted the uncertainties and the ambiguities there. It may be in time that that results in a new piece of legislation or new rules relating to working from home, such that minimum number of hours and break times and things are more relaxed. But at the moment, it's an area where employers and employees need to tread carefully, because the WorkSafe Authority will investigate employers who are not complying with the law on working hours. The final 2 points I wanted to raise are both in relation to tax and superannuation. We often find when advising clients on relocating employees to work here remotely that these are the two biggest practical hurdles to having people in Australia, partly from an administrative aspect and also from a sort of financial burden, because the superannuation can't be deducted from salary. It must be in addition to salary. And that is the end of my presentation. Thank you.
Thank you very, very much, Alan. And you can see it's a lot more restrictive there in Australia than it is in the UAE. I've found the health and safety point you mentioned quite interesting, because I think when COVID hit and everyone was working from home, there was quite sort of relaxation on the health and safety. But now, as employers don't need to work from home, you're starting to, it's interesting to see in Australia, you're seeing that the authorities are taking that more seriously and imposing that obligation. And when you're doing that cross-border, that's even more difficult. I think if you're an employer in Australia and your employee's working from home, perhaps it's a little bit easier. But where you're in another jurisdiction, that I can see, the employers in another jurisdiction, I can see that being more complicated. I'm now going to hand over to Dzung, who's a senior associate in Vietnam, who's going to give us an overview of the position in Vietnam. Over to you.
Thank you, Devan. Hi, everyone. I'm Dzung from Hanoi office. I will briefly go through the overview of Vietnam employment law and then discuss key legal issues of cross-border employment. First thing, that is a labor contract in Vietnam. We have two types of labor contract, and that means the definite term contract can be agreed among the party with up to 36 months and twice in a row. And then the third one must be the indefinite term contract. However, with respect to foreign employee working in Vietnam, they will sign up to 24 months labor contract, which is according to the maximum 24 months of their work permit in Vietnam. We get in the NDA and NCA. Basically, signing NDA and NCA is permitted in Vietnam. However, it's prudent to separate both NDA and NCA from the labor contract to secure their survival after termination of the labor contract. Termination of a labor contract is extremely difficult and complicated in Vietnam. For example, it requires a legitimate reason, and all the mandatory procedure and timeline must be strictly complied with. For example, employer may terminate labor contract due to poor performance or due to force majeure event leading to the reduction of the labor workforce, or due to the employee absent from the work place for 5 consecutive days, or in other case, dismissal can be applicable. For example, the employee committing some kind of sexual harassment, using drugs as work, or disclosing secret technology of the company, or in case the employer implements some kind of restructure organization restructure or change of technology, or due to the economic reasons that they must to reduce their workforce, and then it could qualify for legitimate reason for termination of labor contract. You can see that there are several thresholds set out by law regarding the working hour, overtime, and annual leave, public holiday for all employees working in Vietnam. For example, regarding the annual leave, there are 12 working days and 11 public holidays. With respect to foreign employees working in Vietnam, they will be entitled to additional one traditional holiday and one independent days of their home country. Also, in case having 10 or more employees, then the company must develop and register into labor rule according to employee handbook with the labor authority. Also, the law set out the minimum salary to be applicable differently in four main regions of Vietnam. For example, for Hanoi and Ho Chi Minh City, which city in Vietnam, the minimum salary is around $197 per month. There are three main mandatory insurance contribution under the Vietnamese law, namely social insurance, health insurance, and unemployment insurance. The last one, unemployment insurance, shall not applicable to foreign employee working in Vietnam. And basically, employers will withhold and make payment of such contribution to the relevant insurance funds in Vietnam. And the basic for calculation of contribution will be capped by law, for example, 20 times of the basic salary for social insurance and health insurance. And for the unemployment insurance, it will be based upon the cap of 20 times of reasonable minimum salary. Talking about the PIT, depending on residence status, the employee will be subject to different requirements on PIT. For example, for tax resident, their worldwide income tax will be taxed. Meanwhile, for non-tax resident, only revenue generated in Vietnam will be taxed. And employers is responsible to declare, withhold, and making payment of PIT on behalf of the employee to the tax authority. Basically, employers can hire foreign employee to work as manager, specialist, or technicians in Vietnam. Of course, a lot of qualifications set out by law must to certify. Creating the recruitment procedure is quite complicated and time-consuming. For example, it requires developing the plan, submitting the same to labor authority for approval. And just after receiving the approval from the labor authority, then the party can proceed with obtaining work permits and then visa for relevant foreign employees in Vietnam. Next, please. And talking about cross-border employment here, and there's increasing demand for cross-border employment in Vietnam right now. And normally, the common question here is that, can foreign employer sign labor contract under Vietnamese law with employees working in Vietnam? And from the legal perspective, it's not clear, as the wording of the labor code is vague. However, from the practical point of view, the answer is quite simple and says no. because there's no procedure regarding registration of foreign employers in Vietnam. Therefore, there are no procedure for employers outside of Vietnam to withhold and to declare or to make payment of PIT or mandatory social security for their employees. And also, they cannot sponsor work permits or visa for their foreign employee working in Vietnam. So practically, there's no regime for them to do so. So the next question is that what option for foreign employer to consider here? And in the paper, we list out the 4 available options for foreign employer to consider with according pros and cons. For example, in the case of using employer of record service, of course, there's no burden getting the labor contract termination, making payment or visa or work permit sponsorship. Yeah, but that's the biggest disadvantages of this option is that there's limitation of periods, just less than 12 months, and then it's only permissible for 20 job in Vietnam, and also they must pay the fee to the service provider. With respect to consultancy contract, it's quite simple, but there's no scheme to sponsor visa and work permits for foreign employees in Vietnam. If considering setting up the Vietnamese legal entity, a company or rep office in Vietnam, this can have the employer with providing the full sponsorship getting the visa and work permit for foreign employee. However, when enjoying the legal right under the labor code, in doing so, they will also be imposed upon all kind of obligation under the Vietnamese law. So, welcome to Vietnam law. That's all my presentation today. Thank you for listening.
Many thanks, Dzung. And that was really interesting. You know, the challenge that Vietnam presents for that cross-border working, and I think it's an interesting point. You know, legally the position might be X, but it's the practical issues. And you know, obviously, if you're posting an employee in Vietnam, you have to think about perhaps alternatives to straightforward employment. Before I hand over to Damien, just a reminder, there's the Q&A tab. Please do ask your questions. Please do put your name there in case we don't get to your questions, but do take advantage of the Q&A tab. We'll have a chance to ask all of our panelists questions at the end. So I'm now going to hand over to Damien, who's going to provide us some insights. He's a partner in our Singapore office, provide some insights from Singapore. Over to you, Damien.
Many thanks, Devan. Yeah, so just kicking off with the first slide, I mean, it's no secret that Singapore is very highly regarded for its business and economic competitiveness, for its availability of a skilled workforce, and for its undeniable livability. And as a result, many multinational companies have chosen Singapore to base their regional headquarters for Asia. During the last year, some of the employment trends that we've seen are around demand for skilled workers, particularly in identified growth sectors such as information and communications, financial and insurance services, particularly as it relates to the green economy. So that would relate to things like carbon markets, professional services, and also in health and social services. And also, again, not surprisingly, in so far as technology is concerned, so SEB, software, web, multimedia developers, software and applications managers. These are all skills that are highly sought after in the local workforce. Similar, though, to Australia, it's not a case that you can just turn up in Singapore and start looking for work. All foreigners who intend to work in Singapore have to have a valid work pass before they start work. And all employers seeking to engage foreigners must ensure that those employees have valid work passes. And this manifests through an application for one of a number of passes and then getting an approval in principle to enter the country for purposes of starting work and converting that approval in principle into a valid work pass. We'll come to some detail on that during the course of the next few minutes. Also relevant to what I'll touch on in the context of current criteria for availability of passes are certain sectors that the government has recognised are needing top talent because of the finite nature of the workforce here, and that includes, as mentioned earlier, things like agri-tech, financial investment services, green economy, healthcare, research, academia, science, technology, sports, arts and culture. Next slide, please. So this looks quite busy, but it just seeks to outline some of the key passes that are under consideration and are available. The first one is the most relevant for foreigners looking to come to Singapore to work for a period for a locally based company, and that's the employment pass, or EP as it's known. That is targeted towards professional managers and executives from abroad, and there's a minimum threshold salary that needs to be earned in order to qualify. There are other criteria, and we'll come to those shortly. Entrepass, as it suggests from the name, is geared towards entrepreneurs in particular, and there are two conditions there insofar as they have to either started or intend to start a private limited company registered with companies registry ACRA here, and they have to meet criteria of either being an entrepreneur, innovator, or investor, and that's a subjective assessed criteria as to whether they meet those criteria. The personalized employment pass is a longer term non-employer linked version of the employment pass, where the employment pass is effectively applied for and sponsored by an employing organization. The PEP is linked to the individual and is for a longer period. Again, salary thresholds apply in that regard. And then if you could describe it as being at the top tier, designed to attract the very best talent in business, arts, culture, sports, academia and research, is the Overseas Networks and Expertise Pass, or ONE Pass, which has a very high minimum salary. Next slide, please. So just focusing on the employment pass eligibility framework, the situation has been evolving and has changed, so with effect from, or will change with effect from 1st of September 2023. So there will be a new system which provides arguably greater transparency around the criteria required to successfully apply for and be granted EPs, whereas before it was largely based on qualifications and minimum salary thresholds. It's now based on a more points-based system. There are effectively two stages: the qualifying salary and the complementarity assessment framework, or COMPASS, as it's more conveniently known. In the qualifying salary category, as mentioned earlier, there's a minimum category in all sectors except financial services of 5,000 Sing dollars a month, and that's 5,500 Singapore dollars per month in financial services. And you'll see that those rise with age, largely designed to reflect increasing seniority and the expectation that increasingly senior employees will be paid increasingly large amounts of salary. Moving to the points-based system, as indicated here, there are 4 foundational criteria that apply to that, and there are some additional criteria. As far as the foundational criteria are concerned, EP applications earn points for each criteria. You have to earn a minimum of 10 points in each criteria to get your minimum threshold 40 points to pass COMPASS, but you can, if you exceed expectations, gain 20 points in each criteria. And being able to satisfy this when you plan workforce moves and relocating people to Singapore and applying for employment passes allows firms to better predict the likelihood of success of those applicants being awarded EPs. So just moving to the next slide to see what those criteria look like. This is very busy, deliberately so, but it's actually quite simple once you break it down. So this refers in the top table to the foundational criteria that are assessed with regards to salary, qualifications, diversity, and support for local employment. The salary is by reference to local professionals, managers, executives, and technicians. That's the PMET reference. By age, and you score points depending on where you sit in the percentile relative to that local PMET salary norms. The qualifications is based on candidates' qualifications by reference to whether they graduated from a top-tier institution or had a degree equivalent qualification. Diversity, again, is by reference to the national standard and whether the candidate improves that national diversity. And then the fourth criteria around support for local employment is based on sectors. The bonus criteria specifically looks at skills that are required. The C5 and C6, so C5 looks at skills and awards bonus points above the minimum threshold 40 points by reference to a shortage occupation list. And there is a published list, as I referred to earlier, which looks at specific areas in which skills are in short supply and that the government is looking to develop from a national level and therefore seeking to attract foreign talent. That was released at the end of March this year and will be updated as things evolve to reflect the changing national priorities. There's also in C6 the opportunity to gain bonus points by reference to specifically assessed criteria relating to investment, innovation, internationalization, or company and workforce transformation activities. Okay, moving to the next slide. So as far as Compass exemptions are concerned, if you earn at least 22,500 Singapore dollars fixed monthly salary, then you are exempt from the Compass requirements. Similarly, if there is a overseas intra-corporate transferee, then that is an exempt category, and similarly filling only a short-term role or a role on a short-term basis is exempt. There is a self-assessment tool that is expected to be released in September 2023. It may come a little bit earlier, and there are certainly calls for it to be made available during the summer, even on a beta basis, so that firms can begin to test the system alongside their own workforce planning requirements and to essentially predict the outcome of success for applicants for EPs. So we look forward to seeing how that rolls out over the next few weeks and months. Next slide, please. Also worth bearing in mind alongside the threshold requirements and criteria for EP application is the Fair Consideration Framework, which, as it says there, sets out the requirements for employers in Singapore to consider the workforce in Singapore for job opportunities. There are some exemptions to this as laid out in the second bullet point in the subpoint, but basically what it amounts to is that employers who are putting in applications for foreigners to be granted employment passes must first advertise the role that's available on a government website for 14 days, and they have to give fair consideration to candidates. So this is designed to ensure that jobs are not just being granted without fair thought and consideration being given to the availability of skills in the local workforce. There is also an expectation that employers in Singapore adhere to the tripartite guidelines on fair employment practices, and there are penalties for non-adherence to those. There is also a fair way further down the track going to be where encouragement for flexible working arrangement is currently given. There will be a mandatory implementation of policy around flexible working arrangements, which will require firms to at least have a policy and process to consider applications for flexible working arrangements. Failure to have a policy in place will be a breach, but it does not mean that companies will be required to accede to requests for flexible working, only that they at least have a system by which they consider those requests. And then my last slide here, if we can just move on, is just some practical considerations for employment passes. So as far as the applicant is concerned, it would need to be the employer, or if the employer is in the process of setting up a company or subsidiary in Singapore, then alongside that setup, you can use appointed employment agents who can make the application on behalf. If you do not have a Singapore registered office, then you have to go through a local sponsor, and there are organizations that can assist with that. As far as qualifications are concerned, you have to have regard to the relevant qualifications, and that will become increasingly more important as we look at the foundational criteria in the Compass framework. As far as application time is concerned, it's all done online through the Ministry of Manpower website, which is incredibly easy to navigate, and applications are processed or an update is given within 10 business days. There is an application fee, which is relatively modest, And as far as duration of e-visa concerned, typically it's for 2 years first time around, but there may be longer periods for specific skills shortages, gaps in the market. There are also, as mentioned earlier, conveniently and not surprisingly, there are professional employment organisations who exist here, but they are largely geared more towards sourcing already locally based candidates in the market who possess the necessary rights to work. If you are looking at relocating foreign workers into Singapore, then all that I've said above is relevant to that consideration. And I'm going to leave it there to give us, I think, 60 seconds for Q&A, but hopefully a bit longer. Thank you.
Thanks, Damien. And clearly, the employment pass is there's quite a lot of hoops to go through in Singapore. Though it's interesting that there is an option for people to have sponsorship without their employer being based there. Okay, so I mean, what I found interesting today was how varied the rules were in all the jurisdictions. Very different from Europe, where there was an element of sort of consistency across the jurisdictions because of European law. And what that means is, as employers, you should exercise caution when employees are asked to work in a different jurisdiction and look at the rules there and really put in place a policy to make sure that it's at your discretion as to whether you let the employee do that. So we would recommend that. Now, we have come up to the hour. We are happy to stay on for a short while to answer some of our Q&A. I appreciate some of you may need to drop off, but if you can stay on, please feel free to. It'd be great if you can while we do the questions. Just a reminder for those who will be dropping off, you will get a feedback form. So please do complete that. Your feedback will be greatly received. And also a reminder of our last webinar in the series, a bit of a gap, is on the 14th of June, where we'll be covering France, Spain, and Greece. So do join us for that one. But those of you who can stay, please do stay for the Q&A. Okay, so we've got a couple of questions which we are going to go through now. The first one is going to be for Charlotte in Dubai. And the question is, if I need to terminate the employment of an employee in the UAE, am I responsible for ensuring that they leave the country?
Thanks, Devan. Well, generally, when you terminate an employee in this jurisdiction, you need to make sure that you've paid that employee everything that they are due, including the salary and the end of service gratuity, if that applies. And you then need to make sure that you take steps to have the employment visa terminated. In some cases, you will be responsible for paying for a repatriation flight, but you're not actually under a legal obligation as an employer to make sure that person leaves the country. As you'd appreciate, they may well be looking for another job or have another job to go to. And so it's incumbent on them to make sure that they have the rights to remain in the country under the relevant laws until they have their new employment visa in place.
Thanks, Charlotte. The next question we have is for Damien in Singapore. The question is, how does it work from a tax perspective with regards to expatriate employees?
That's a very short and simple question, which tax is never a short and simple answer. And I'm conscious that there are some tax professionals on the call, so I won't seek to oust them. But from an expatriate perspective, pure and simple, the tax liability from an employment income tax perspective rests with the individual. There may be auto-inclusion of employees, foreigners included, by companies within the tax assessment, but ultimately they are the ones who are responsible for settling their tax affairs with IRAS, the Inland Revenue Authority of Singapore. How that translates, and sorry, I should just also add to that there is no obligation or entitlement for EP holders alone, as distinct from citizens or permanent residents, to contribute to the Central Provident Fund system. But what that means, I think similar to what Charlotte mentioned there from a termination perspective, is that it's incumbent on an employer upon termination of an employee's employment arrangement to withhold at least a month's salary in order for them to effectively be tax cleared. So they have to be tax cleared by IRS. They have to settle their tax affairs, and the employer is under an obligation to cancel and return their employment pass within 7 days from the date of termination of employment. So in simple terms, tax is the employee's responsibility, not the employer's responsibility, but there is a residual obligation to effectively account for tax at the end of an employment arrangement. I hope that answers the question sufficiently.
Thank you, Damien. We've got a question for Vietnam. So we've got Dzung and also Lindoan, who heads our Vietnamese office, on the line as well. And the question is, how easy is it to obtain a work permit for recruiting an expat, and what are the key requirements?
Thank David for the question. As I mentioned, obtaining work permits in Vietnam for expats is quite difficult and complicated. As I mentioned in the presentation, firstly, the employer needs to prepare a plan and then submit a plan to the relevant labor authority for approval. And after that, they will prepare the whole application dossier for obtaining the work permits. And in that application dossier, they must include some kind of qualification documents, supporting document getting the experience of and qualification of relevant expatriate employee. For example, for the specialist working in Vietnam, it requires 5 years of experience or bachelor degree with 3 years of experience, for example.
Yeah, I mean, we are happy to assist our clients in making the application for this work permit.
Thanks, Lynn and Dzung, and as Lynn mentions, please do get in touch if you've got questions about any of these issues in any of the jurisdictions we've spoken about today. The details of all the speakers are on the slides. We've got one question for Australia here for Alan. Does setting up an Australian company avoid the application of Australian employment law? Alan?
It's a good question. No, it doesn't, because once you set up the company becomes responsible for all of those obligations as an employer. And to some degree, whilst you could ring fence liability to that company, it does create a liability for the parent company. And for example, the tax office will have no hesitation in going after the parent company if the Australian subsidiary doesn't meet its obligations.
Okay, so no quick get out there, unfortunately. Okay, I think we've obviously gone a bit over. We're going to wrap up there with the questions. As I mentioned, we've got all the details of all the speakers there. Do get in touch if you've got any questions on this issue or any employment issue in any of these jurisdictions. Do feel free. I want to take the opportunity to firstly thank all of you for joining us on the webinar today. Please do complete the feedback form for us. And lastly, I want to thank all the speakers for your insight today. Just seeing all the contrasts in different countries was very interesting. So thank you all. Thanks for your participation.